SJC-10572, Commonwealth versus Cartright.
Mr. Nixon, good morning.
Good morning, Your Honors. May it please the Court, Kevin Nixon for Mr. Cartwright. Now, all of Mr. Cartwright's claims on appeal concern the confession that police took from him after his arrest when he was interrogated by two police detectives. And I'd like to spend my time discussing the question of whether the statement should have been suppressed as involuntary. In other words, whether the judge, when denying the motion, erred by concluding that the government had proven beyond a reasonable doubt that it was voluntarily given. So,
before you get there,
yes.
am I correct that the only indication that the judge found it voluntary is in his denial of the expert witness, or in the, I didn't find any decision regarding the motion to suppress. I just found a decision regarding the denial of the request for an expert.
I know it was delivered orally, Your Honor, and I know the memorandum you're referring to about the expert, I think it was Professor Hirsch, and his testimony. I think he felt compelled to write that as some guidance for the trial judge, because he was not going to be presiding at trial. He wanted the.
But you're saying that there is in the record his findings made orally?
Yes, Your Honor, I believe so. I think they're included in Mr. Jacobson's brief, but I believe that was the ruling at the conclusion of the motion hearing.
Gosh,
I don't think it was an extensive finding of facts. Maybe Mr. Lynn could help me out on this when it's his turn to address the court, but there was no question it was denied, and there was no question that the issue being decided was whether or not it was voluntary or not.
So if there were not separate findings, is that any issue that we need to be concerned about, or can we simply look at the video ourselves and form our own conclusions?
That's what's suggested by both parties here, is that the issue is before this court de novo, because it's a DVD of the interrogation from start to finish that really makes up the record here, and that you're not bound the way you would be to defer to the motion judge's conclusions, but are at liberty to conclude or to consider it de novo, given that the fact that the record consists of a video recording that you're as able to evaluate as the motion judge was. So I urge you to do that, of course, and I think the parties have agreed that is the standard of review.
I thought we usually look at videos to see if the judge is, we accept the judge's findings, of course, but don't we usually use those to evaluate whether the judge's findings are clearly erroneous?
No, I think that there's case law cited in both briefs before the court that suggests that when the record consists of a video,
Right.
This court is just as able
Okay.
to evaluate that record as as the judge was in the trial court. Of course, it's a lot different than where a judge hears testimony and
Okay.
makes evaluations of credibility of witnesses. Then, of course, this court would be bound on appeal to defer to those credibility findings and the ultimate factual findings of the motion judge. So here what happens is the defendant is arrested about 8:45. He's taken to the police station where two police sergeants, Sergeant Condon and Sergeant Dana, begin an interrogation after he's already been held just kind of waiting in a room for 3 hours. Sergeant Dana has met the defendant 4 days earlier when he went out to the apartment to inquire about the defendant's missing mother, and had learned at that time that from the defendant, Mr. Cartwright, that the defendant said something. It's unclear what exactly he said. It's in volume 3 of the trial transcript. But Mr. Cartwright had made some reference during this meeting on September 1st at the apartment to the mother's practice of voodoo. So Sergeant Dana has met the defendant before. Sergeant Conn is meeting him for the first time in this interrogation. The briefs divide the interrogation, I think, rightly into 2 parts. There's the first part that goes on for about 2.5 hours, and that's the defendant or the detectives letting the defendant talk. They're asking him about his mother, about her cell phone, about what he's been doing, about himself, and then they take a short break and come back, and the interrogation turns accusatory. They tell him that they know he murdered his mother. They already got the proof to make their case.
When in this do they tell him that she's dead?
After the break.
This is after 2.5 hours?
Yes. Yes. They come back and they tell him, we know where your mother is. We found her in the closet. We know you killed her. We have enough to prove our case, but we want to give you the chance to explain why you killed her. And then Sergeant Condon's taking the lead in the interrogation at this point, and he's using the usual sort of read techniques of minimization and other things that you see in lots of cases. They tell him that he should just explain what happened. These things happen all the time. And we know you're a good kid. They're doing those sorts of things, trying to elicit a confession. Mr. Cartwright, though, keeps insisting that he didn't do it. He doesn't know what they're talking about. And why would he do such a thing? When Sergeant Condon's minimization and read technique efforts begin to founder, Sergeant Dana steps in and begins to talk with Mr. Cartwright about his mother's time in the afterlife.
Well, the way it's characterized in your brief versus the way it's characterized in the Commonwealth's briefs versus the record.
Right.
I mean, I would say that in this argument, the Commonwealth might have a better point with regard to including the entire statements.
I know what you're talking about, Your Honor, and I think if I had written this brief, I would have just included all of it, because I don't think the parts that Mr. Jacobson admitted from his recitation of the facts there, of the DVD, really make any difference. So with all due respect to Attorney Lynn, I don't think that seeing those parts that were omitted really changes the power of the argument, because I think there's some, what you're saying about him, I think it's a stretch to say that Dana was saying that the mother's spirit was burdening the siblings. I think that's a stretch. But the part that's not a stretch at all is when Dana is telling Mr. Cartwright that his mother's time in the afterlife is being troubled, that she's never going to find peace in the afterlife. These are his words. The afterlife is deployed several times during
And
the
what was the
interrogation.
indication in that frightened the defendant?
Well, the indication is that finally he's begins to confess. He's taken all.
And is it because he's afraid, or is it because of the appeal to putting his younger brother and his older brother's minds at ease about what actually happened?
Well, he doesn't specify which one is motivating him. But what happens is that the minimization techniques that Sergeant Condon deploys are unsuccessful. Sergeant Dana goes to talking about the afterlife and his mother never finding peace in the afterlife.
And isn't there also discussion about why don't you be a man?
Why don't you be a man, man up? There's also Sergeant Dana starts telling him that he's going to grow ill and go crazy, basically.
Wasn't he already having trouble sleeping and
That-
having
that can-
nightmares and so
that-
forth? So that's
the-
now he's going to grow ill. He was.
The sergeants had learned that during the first part of the interview and in interviewing his girlfriends before they began the interrogation. So that's what makes this case different, is that the invocation of the mother's resting at peace in the afterlife, and that the fact that the claim that she will never find peace in the afterlife, unless the defendant, Mr. Cartwright, confesses to the detectives and tells them exactly how he killed her. Those things are especially powerful here because Sergeant Dana knows from his previous conversation with the defendant on September 1st that the family subscribes in some respect to the beliefs of voodoo.
And we know this because of trial testimony? Because that's not in the,
That's actually referenced in the brief. It's in volume 3 of the trial testimony at page 48, I think, where Dana, or one of the defendants, it might be Cohen, who was with Dana during that visit on September 1st, says the defendant had said something about mom's involvement with voodoo. And then later, during the interview, this comes up again, Sergeant Dana asks, or maybe it was Condon, one of the detectives asks, did you ever say anything bad about your aunt and your mother? Because they know from other interviews that the defendant sees his aunt as sort of the primary mover behind the troubles he's having with his mother. And he says, yeah, it was. I did say something about wanting to harm them, but that was because of the voodoo. So that comes out again during the interview or during the interrogation.
Isn't it more, well, when I looked at the tape, it seemed that the confrontation with the fact that we know that you did it with the cell phone, that the cell phone was really the turning point.
I'm sorry, I don't.
That the shaking, when he started shaking with regard to the cell phone.
Yeah, that had been several days before his arrest. There was an incident, like, you're right, Your Honor, there was an incident involving the cell phone. His younger brother says, that's Mom's cell phone.
But that's not when he started shaking, is it?
It was when he started shaking,
Okay.
yes. That did not lead to his, arrest. It just led to further investigation days later. I mean, I think Mom was reported missing on August 27th. Her body was finally found in the apartment on September 5th when the
Okay.
police were
I
executing
see.
a search warrant.
I'm not quite sure if I understand the importance of voodoo. Are you saying that the defendant himself believed enough in voodoo to be influenced by these statements, or that his mother did?
I'm saying he did, Your Honor. I'm saying he did.
And what is the evidence that he did?
Two things, really. One, he suggests that Mom might be missing because of something involving voodoo, and he offers that as a avenue that the police might want to investigate in their search for her early on.
that comes out during the,
That's on September 1st when they're visiting the apartment. And
well,
then
on September 1st, he says, in connection with the cell phone, he started to talk to me about voodoo that his mother was into.
Yes. Well, he's a 19-year-old man raised by his mother.
Well, okay, but I mean,
But
where's
then-
the other one about?
Well, then
his
there's
mother might
there's
be-
another piece of this, which is the interview on September 5th,
Oh, okay.
when
September
they
5th,
say,
is
well,
that-
did you ever say you wanted to harm or tell anyone that you wanted to harm your aunt
That's the
and mother?
confession?
Yes, that's the confession. And he says, yes, I did say that because of the voodoo. Now, you don't want to harm someone because of the voodoo unless you believe that the voodoo has some special power and, warrants that sort of action on your part.
Do you have a reference for that, by the way?
The voodoo, yes, Your Honor.
I'm sorry, I don't want to detain you. You can always.
I'm sorry, Your Honor.
You can always send that in later.
Because I didn't. Yes, Your Honor. Thank you, Mr. Lynn. It's at the DVD, hour 3, minute 18. Sorry, not having written the brief, I don't
So,
know it as well
Mr.
as I
Nixon,
would.
I'm kind of with the chief on this. I just see this voodoo discussion as a big red herring. What does it have to do with anything?
Well, I think that it's meant to fill the gap, in this argument, really, about how would, suggesting to the defendant that his mother was going to never find peace in the afterlife mean anything to the defendant unless he also believed in the afterlife, right? If you just have a materialist viewpoint of life and death, I mean, threats about what Mom's going through in the afterlife aren't going to hold any power with you. Did that make?
No.
Well, if you don't believe in the afterlife yourself, then a police detective telling you
Well,
that mom's
that's not
suffering in the
necessarily
afterlife won't mean
voodoo.
anything
I
to you.
mean, Christians believe in the afterlife. So I
Well,
don't
but
get
not
what,
everyone's a Christian, and
I get that.
So would then only religious people would they have a separate situation in an interrogation than atheists?
No, I'm not saying that. I mean, like I said, it's meant to fill in this argument the problem that might otherwise exist, which I'm sure that Mr. Lin would take advantage of. That there's no proof that the defendant, because all this is about what's going through the defendant's mind, of course, and when making a determination of whether it's voluntary. And of course, if you have a defendant that doesn't believe in the afterlife, that you could somehow demonstrate did not accept those beliefs as his own,
But
then
it seems like you got to come up with something other than voodoo to get
Well,
to involuntary.
I think there's enough here, really. The defendant did not testify at the hearing, but we know that he was raised. He came from Haiti 6 years earlier. At the age of 13, he was 19 at the time of this incident. He was raised by his mother. The police know that mom and his aunt were either practicing voodoo or followers of voodoo.
Well, they know he said that. They don't have any other independent.
Well, it's evidence. It is evidence. And they know, too, that during and they knew during the interrogation that when they confront him with, this accusation of him having previously made some, disparaging or threatening remarks against his aunt and mother, he said, well, that was because of the voodoo. And so they know that he believes in voodoo because he's, if you want to threaten people because of their voodoo, you believe in it too.
But it also suggests, doesn't it, that he's not afraid to threaten them because of the voodoo?
Sure, I mean, it cuts both ways, but it I think helps establish, his mental processes and what his mental state was while he's being interrogated, and and told that mom will never find peace in the afterlife unless he, steps up like a man and confesses to her killing.
Do we have any cases in which, or federally, are there cases in which the rest in peace theme was found to render a statement involuntary?
Well, Mr. Jacobson did a good job in the brief, in pages 40 through 42, of collecting cases that are close, not exactly on point to this one, but contain elements of this case from other jurisdictions. And I am not aware of anything from Massachusetts that is exactly on point, Your Honor. But what we're asking the court to do is, after reviewing those cases and the facts of and the evidence of what happened here, is to align Massachusetts with those jurisdictions. So there are cases not from this state. So I know I have just a couple minutes more, but I wanted to say something about the Rosario argument that's also raised here about the 6-hour safe harbor. The parties did some. This wasn't raised in the trial court, so the record's not really perfect on this. But there's fair reason to believe that the confession began at 6 hours and 7 minutes, is I think the number that's calculated by Attorney Jacobson, and that it didn't start with I killed mom. There's probably another 15 minutes of confessing before the confession concludes. And then after all that's done, at 6 hours and 40 minutes, I think it is, they have the defendant sign a Rosario waiver. And the routine way that these things are being, the Rosario rule is being dispensed with by the police in reliance on the at any time part of the Rosario decision when it discusses waiver, is, I think, exemplified by what happens here. This is at page 598 of the appendix. And they have a full confession, and then Sergeant Condon says, okay, this is basically, since you've been here for 6 hours, we have to advise you of further rights. He's been there over 6 hours. They haven't signed a waiver. The only case I could find where Rosario, or at least recent case where Rosario was enforced against the Commonwealth was Commonwealth versus Lowell from 2014. That involved a 9-hour delay with Mr. Lowell being held in custody. And the only thing the police did there is they forgot to have him sign a waiver. My point is that whatever the values are supposed to be served by the Rosario rule are so easily defeated by the Commonwealths and the police continuing to rely on this dicta that in the Rosario decision that allows the defendant to waive his Rosario rights at any time, as to make those protections hollow, which is what Liakos had called them in his dissent in that case. Thank you, Your Honors.
Okay, thank you. Mr. Lynn?
Good morning, Your Honors. May it please the Court. Paul Lynn on behalf of the Commonwealth. With me is Assistant District Attorney David Fredette, who tried the case. One thing I would like to clarify from the start is the timeline regarding the cell phone. The murder, the victim is last seen on a Saturday morning, that's the 26th, I believe, Saturday 26th, leaving the hospital. She's presumably, according to the defendant's confession, murdered that morning. On Sunday, he calls, Sunday, August 27th, he calls and says he's concerned about his invalid grandfather and his brother because his mother hasn't come home. And social services comes out and they ask if Noah's father is around, and that's when Noah says, it'll be on my mother's cell phone, which is the one that the defendant is holding. He points to it. And the defendant says, oh no, that's my cell phone. There's a completely separate incident on that following Friday, the 1st, in which they say, now they've talked to the girlfriend, and they say, we know you've used the cell phone. And that's when he starts shaking, even though it's mid-August. And that's in the context in which he says, in which the detective says he starts talking about the voodoo that his mother is into. And then again, there is that other reference to voodoo in the interview itself, in which they confront him with the fact that he said, threatened to kill his mother and aunt, and he says, I did because of their voodoo. And again, that's not recorded in the transcript. It's said inaudible, but I agree with defense counsel that you can't hear. He does say because of the voodoo or because of their voodoo. It's not quite clear. But there's no evidence whatsoever of the defendant's own religious beliefs, that he's particularly impressionable, that he believes that he's going to be haunted, and certainly what the detectives say to him never suggests that his mother is going to haunt him or trouble his family. They're just simply saying, she's restless. She can't rest in peace because of what you've done. Your family can't rest in peace because they don't know what happened. Be a man, step up, do the right thing, tell us what happened.
Is this akin to the Christian burial?
Well, that goes to functional equivalent of interrogation. There's no question they're interrogating him. The Christian burial was that when they said that, they were enticing the defendant to say something in violation of Miranda. That's not the question here is whether it was so overbearing that it sapped the defendant of his free will. And the DVD as a whole, and I will say, just to interrupt myself here, I couldn't find any findings in the record. I looked. The judge, if there were findings, he does make some findings regarding voluntariness in his memo regarding the expert witness, but this is really de novo because the DVD shows what it shows. You can watch the interview as if you were there. It shows he's fluent in English. He says that he has enough credits to graduate from high school, and his brother testified at the hearing that he was going to a technical school. The former defense counsel said that was his last year in school, was his first year at Chelsea High. That's just not true.
Did you say he testified at what hearing? At the motion to suppress hearing?
Yes, the brother did, I believe. I think that's correct.
All right,
yeah.
Okay. So the judge heard evidence other than the...
The judge did hear evidence, but I think...
So we don't have to worry about that because that's not on DVD?
That's not on DVD, but the facts...
Make findings as to that?
Not that I can find. You know of any? I certainly don't know of...
So we basically can disregard all of that stuff?
It's there, the facts aren't disputed. I don't think there's any dispute that the brother testifies that he was going to a vocational school. That's not disputed. That never was
Who else
challenged.
testified at that?
The officers testified, and
So we can't necessarily credit anything they had to say, because we don't know if the judge did or not.
right, I think it's better to say that it was never contested, but it really adds, there's very little of the testimony at the hearing that adds anything to the DVD. There's these peripheral things like the brother saying he went to a technical school that just sort of flesh out what happens on the DVD. But there's no great revelations that would help the Commonwealth or hurt the Commonwealth at the hearing. But yeah, continue.
I guess the question is, what are the limits? I mean, what is the theme of, you need to tell me what happened so that your mother can rest in peace and so that you can rest in peace and your younger siblings can rest in peace. What do we do with that in terms of what that's supposed to elicit?
It's essentially the officer saying, listen to your conscience. That's a totally acceptable appeal by the police. There's no law that says that the police have to discourage a defendant from confessing.
Well, I understand, but if I'm listening to my conscience, the issue is not whether the other person will rest in peace.
True.
That speaks of something else.
I would point to the cases cited in my brief. Carrington leaps to mind, the California case, in which the police officer says, there's someone bigger than us watching this, and he knows you shot him. And the California court said, that's not over the line. The things that have been over the line, and in the Mississippi case, Lee, I'm not sure it's L.E., is exactly on point, and where the officer said that the victims couldn't rest in peace unless the defendant confessed, which was upheld. The cases in which the courts have held that the police stepped over the line are situations like you're gonna go to hell, you're gonna face eternal damnation if you don't confess. God is going to make you insane if you don't confess. That's the sort of thing that steps over the line. Here, this is really just the kind of platitude you would offer to someone at a funeral. Yes, your mother's in a better place now, something like that. This isn't you're facing hell. Your mother's going to suffer for eternity, or as the defendant, my predecessor, his brother's predecessor said, he's going to haunt your family. There's no suggestion of haunting here. This is just.
Well, how about haunting you? You won't be able to sleep. You'll never be able to be well again.
He doesn't. The detective, Dana, never says that. He says, your nightmares are going to get worse. It's going to keep eating at you. That's the extent of all he says. That's just amateur psychology. It's not a threat.
I mean, it's a matter of degree. I mean, you just say basically, if you say you're going to go insane, that's too much. If you say you're going to get nightmares and you're never going to be able to sleep again, you're sort of drawing this line.
Yeah.
And you're saying, okay, that's within the line, but if you go and say it's going to make you insane, it's over the line.
It's
you
true.
Say if your mother is going to go to hell, that's okay, but your mother will never rest in peace in the afterlife, that's okay. I mean, you're drawing a line in which statements speak of issues which could cross that line.
Very true, Your Honor. The line is always fine, and the police are well advised to stay on the conservative side of it. But they didn't do anything here, I would argue, that even approached the line. What they said here were really nothing that would overbear the will of anyone. The defendant characterizes himself, or his former counsel does, as a young Haitian boy who had just immigrated. He's been in the country for 6 years by this point. He's clearly fluent in English. He has all but the degree for a high school education, and you can hear him talk. He's completely fluid. He's completely at ease. The entire first 2.5 hours, they take the break, they come back, and then they say, we've got something to tell you. We found your mother's body, and we know you did it.
How would you have us draft a standard of the rest in peace versus the hellfire line?
I think well, first of all, you look at all the circumstances. That's the most important thing, the entire context of the interview. The distinction here is it something, the standard that already exists, is it something that would overbear the ability of the person to make a voluntary choice to confess? And it just isn't. I think when you say something like, your mother can't rest in peace, your family can't rest in peace, that sort of thing is just an appeal to conscience. When you start talking about, concrete consequences to the defendant in the afterlife, where you're gonna go to hell, that's things like that, where you're actually frightening the defendant, trying to overbear his will, that's the distinction. This is just be a man, follow your conscience, follow your morality, as opposed to...
So what's the context for watching the DVD? I haven't seen it, I'll confess. Do we have findings about this person's susceptibility to that kind of pressure? All I know is that he's 19 and could graduate from high school. But what do we know? Are there findings here about the defendant's mental state and any of that? Are we just looking at the cold video here?
No, there was no evidence really specific to this defendant about his mental state. They tried to bring in the testimony of Professor Hirsch about how the Reed technique has a tendency to cause involuntary, but there's no evidence other than who the defendant is, where he was born, just the testimony that comes out regarding his life, regarding his mental capacity. We know from the testimony that he's almost graduated from high school. We know when he immigrated. We know, but we don't know anything about his mental development, whether he's ever had
The
any...
humane practice instruction was given, right?
Yes, absolutely. Turning very briefly, I certainly will accept more questions on the voluntariness issue.
So do we take the judge's ruling on the expert's testimony as somehow speaking to the weighting that he gave to that testimony at the motion to suppress? Is that somehow part of his findings?
Oh, he definitely makes findings regarding the expert's testimony.
That was part of the motion to suppress.
That was, yes. And there's a written ruling on that subject.
Okay.
And he says he certainly is familiar with this subject, but he's not really qualified. He's just a lawyer who reads this stuff. I'm a judge. He doesn't say this, but the perception is, I'm a judge who can read this stuff. I can make my own determination on this.
Yeah, but I thought, I couldn't quite tell what the judge was trying to do there, whether it was findings as to this motion to suppress or whether it was just sort of to give advice to the next judge coming along. Well, just because I admitted it here doesn't mean you should admit it at trial.
I'm not really clear on what his entire intention was,
Yeah.
but he certainly found that regarding the motion to suppress, this testimony didn't influence him. It's there for this court's consideration.
If I could turn you to Rosario.
Yes.
And I'm trying to go back in time to recognize what triggered the Rosario rule, which is, I guess there was ambiguity as to when extended interrogations make statements involuntary. And the court ultimately said, we're tired of trying to figure this out. We're just going to say 6 hours is going to be the rule. If you have, I assume the reason behind the rule is because there was a concern that you can wear somebody down and render a statement involuntary by the sheer duration of the interrogation.
That's fair to say.
Let's assume you have an interrogation which goes on for 24 hours and you get, on the 24th hour, a waiver of Rosario. Do we need to evaluate whether or not the wearing of the person down affected the voluntariness of that waiver?
That's regarding Rosario, the Rosario rule itself, the safe harbor rule itself. No, I mean, it goes to the voluntariness of the waiver.
No what? No. I mean,
let me explain that better. That was not well said. The court makes it clear that the defendant's statement is admissible if it's made within 6 hours or if at any time the defendant knowingly and voluntarily waives. So you do, of course, you have to look at whether or not the defendant knowingly and voluntarily waived his right to prompt arraignment. And you could consider the fact that it was a 24-hour interview and the defendant was dead on his feet. Certainly not the case here.
Right, I understand that, but I mean, there is a certain, if the Rosario rule was designed to avoid having to deal with whether an extended interrogation is sufficient by itself to render something involuntary, it doesn't really do that if we have to then evaluate whether the waiver was involuntary because of the length of the interrogation.
True enough, but I think the evidence that that's not a problem is that this is the first case in 20 years of Rosario where this has even come up. The police aren't abusing this, and there's, as I say in my brief, there's a very good reason why they're not abusing this, because if for any reason the defendant decides not to waive his Rosario rights after 6 hours, everything after 6 hours is gone.
Which meant here, if he had said, I don't want to waive Rosario, you would have had to deal with the timing of the confession.
Correct. You would have to go back and look at the exact time of the arrest. I would say that he starts his confession, he says, I'm going to jail, aren't I? And starts the confession within 6 hours, about 5 hours and 50-some minutes. And it's at 6:07, both the defense and the Commonwealth agree, it's 6 hours and 7 minutes from this approximate time of his arrest based on the police reports, that he says, I threw the hammerhead at my mother. But even before 6 hours, or at least according to the police reports, within 6 hours, he's already said that he was in the house that morning, he fell asleep, and he heard his mother arriving, and he ran and hid. That's what he says up to 6 hours. So he's already put himself at the murder scene. So this is a situation in which everything is, at worst, right on the cusp of Rosario. The police conscientiously give him the waiver form at 6:45. This is not 6:45 a.m., but 6:45 from running from the arrest. This is not an abuse of Rosario. This is not something that should raise concerns. The police were conscientious. The courts were closed. There was nothing here that would make this court say, we have to do something about this problem, because there is no problem at all. Any further questions? Oh, one more thing that I wanted to bring up, and I'll be damned if I can remember it right now.
I have that problem
if I remember
all
it, I
the
will write a
time.
letter. Thank you.
Words of Oscar Wilde, you must write your most important thoughts down, unless you will surely forget them. So we'll take our morning break.
Thank you.